Welcome to this Legal Aid New South Wales Law Week webinar, Steps to Applying for Citizenship. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. To begin, we would like to acknowledge the traditional owners of the land from which we are broadcasting today. For me, that is the Widjabul-Waible people of the Bundjalung Nation. We also would like to pay respect to elders both past and present and extend that respect to other Aboriginal and Torres Strait Islander people joining this webinar today. Now I will hand over to your presenter today, Lynn Payne, Senior Solicitor with the Refugee Service at Legal Aid. Thank you, Lynn.
Thanks, Bridget. Hi, everybody. I can see that there are about 36 participants. I can't see who you are, so perhaps I know some of you. I suspect that I probably do. You probably know a little bit about the Refugee Service. We're based in Fairfield in the Sydney office of Legal Aid. There are 4 lawyers in the service, plus Nahara Adicho, who most people do know as our Community Engagement Officer. Although we're based in Fairfield, we provide services all across New South Wales to all communities, all settlement communities. We have about 20 clinics a month between the 4 of us across Sydney and Newcastle and Wollongong, and we also do a bunch of outreach to places like Wagga, Armidale, Coffs Harbour and Albury. That's a little bit about the service. Today, what we're going to talk about is the process of applying for Australian citizenship. I'm going to cover the process generally, the issues that will commonly arise for our clients, and that is refugee clients, and hopefully give you some tips on how you can help your clients with this process. Whilst I'm on that, and the issue of the assistance you can provide clients, I think most people who work in this area know that whilst you can't give migration advice to people unless you're a migration agent or a lawyer, you can help people fill out forms. I think this is particularly important with citizenship. Much of the citizenship application forms just ask for factual information, people's names, date of birth, the names of their family, where they've lived. Now, whilst sometimes these questions can trip people up, and if there is something complex about a seemingly innocent question, that's when people need to get legal advice. But if it really is just a simple case of filling out a form, you can do that without being a migration agent or a lawyer. We often get asked that question. Again, if there are no issues with ID or character and your client's not applying for one of the exemptions from the test, which is an issue I'm going to cover later on, then it really should just be a simple form filling process, which you're able to do. In terms of questions, feel free to ask me at the end of each distinct section of the presentation. That will become clear as we work through the presentation. Okay, so let's start with citizenship process. So on the screen is the basic bland process. For most people, the application process will look something like this. You lodge the application for citizenship and pay the application fee. You have to pay at the time that you apply. The fees, which we'll talk about later, very expensive these days. They went up very substantially in July last year. And some people ask whether they can pay by instalments or whether they can lodge and pay later. The answer is no. If you don't pay at the time, it's not a valid application. Once they've lodged the application, they'll then receive, some significant time later, a letter with details of their interview appointment. At that interview, they need to take all of their ID documents that they provided with the application when they made the application, because that would have been copies that they would have sent in with their application. So the idea with the interview is check the original documents, and also to basically have a chat with people. Sometimes for people who haven't done the test, and again I'll talk about those people who don't have to do the test, that interview also serves as a way of the interviewer, the Department of Home Affairs interviewer, just confirming with the person that they understand the nature of the application, that they understand a little bit about the responsibilities of being an Australian citizen, and also, you know, that they understand that they're going to have to do a pledge and what that means. It's pretty simple. I think the reasonably short interviews, generally under 30 minutes, so nothing to be worried about the interview. At that time, sometimes people will simultaneously also be asked to do the test. Now, whether you do the test then or whether you do it later generally depends on where you are. For instance, if you're in the Sydney metro region, you might be interviewed at the Parramatta office of Home Affairs. They also have testing facilities there, so you can do your interview and your test. If you live regionally, then the tests are held in different places. Home Affairs don't have offices out in regional areas, so they might have the test at, say, a Centrelink office. Then they will individually and separately have the interview. So sometimes the test and the interview are together, sometimes they're separate. I'm going to talk quite a lot about the test a bit later on, but that's the next step in the process. Sometimes, again, combined with the interview, sometimes separate. Once you've done the interview and the test, then a decision is made about the application, and that will be conveyed to the applicant, of course. So finally, if the decision is that they're approved, they will receive details of their citizenship ceremony. During COVID, they were all done online. They are mostly going back face-to-face now, and that is both a good thing and a bad thing. It's good because people like the idea that they can attend a ceremony. It's much more formal rather than just sitting behind a screen and just having somebody remotely say, congratulations, you're now a citizen. That's a good thing. On the other hand, it's also elongated the processing time quite significantly. So people might put the application in, do the interview, do the test, get the decision, and then wait 6, 7, 8, 9 months to be invited to a ceremony. Once that happens, however, they'll be issued with an Australian citizenship certificate, and armed with that certificate, they can then apply for an Australian passport. They can't apply for a passport until they get a citizenship certificate, because that is one of the ID documents that you must have to apply for an Australian passport. If you've got citizenship, we call it by conferral. So that's what our clients will be applying for, citizenship by conferral. So that's an overview of the citizenship process. Processing times, which is something that our clients constantly ask us about. Now, I went online yesterday, and you can do this yourself. You can go onto the website of the Home Affairs, Department of Home Affairs, and they will give you processing times, average processing times, updated monthly. So 18 months is the processing times that I extracted yesterday. They were up to, I think, the date up to the 30th of April. So month to month, they'll update them. They either blow out or they tend to never get much shorter. If anything, it increases. What Home Affairs say about the processing time is approximately 90% of applications will be processed within 18 months. That obviously leaves a reasonable amount of applications, 10% of them, which are not going to be processed within 18 months. Some of those 10% will be processed in a shorter time. More likely, though, it will take longer than the 18 months. The things that can blow out processing times are people who have issues with identification. That's a really big thing for many of our clients, or people with character issues. I'm going to speak about both of those issues later. If there are those issues, ID or character, the processing time will increase very substantially. And we certainly have clients who've been waiting 3, 4, 5 years for a citizenship application to be processed. You can see the number of applications for citizenship by conferral is about 130,000. That is huge and going up all the time. It's kind of a controversial area. People have often complained about the fact that, you know, they've waited 4 years to be able to apply, and then they wait another 4 years once the application is made. And Home Affairs will intermittently say, look, we're now putting some more resources into this area. Things are going to improve. It won't be quite so long, but we never see any evidence of that. So if clients ask you, that's standard, 18 months. If you get it earlier than 18 months, you'll be doing very well. Okay, so that's the process, that's the processing times. The next thing is you've got an overview of the process and the applications, how long it's going to take. The next issue is, well, who can apply for citizenship? The threshold issue is the length of time that your client's been in Australia. they need to have lived in Australia lawfully for 4 years or more, and at least 1 year has to have been as a permanent resident. Not many people know that you can be here as a temporary resident. You can even have been here on a bridging visa for 4 years, as long as 1 year, the last year that you've been here, is as a permanent resident. If you've been here lawfully, and what that means, and it's really critical, is that not even 1 day when you've been unlawful. Sometimes, particularly when people have been on bridging visas, there might be a day where there's a delay of a day or so, and they don't even know that they've been unlawful. They've moved from one bridging visa to another and there's been a gap. That means that they've been unlawful and that the clock starts again for the 4 years effectively. Most of our clients have entered on what we call Class XB visas, which are the refugee visas. So this won't apply to them. They're permanent residents when they land. They have to spend 4 years here. And once they've got to the 4 years, then they're eligible to apply. Okay, so the next thing is you've decided that the client can apply, been here for 4 years or more. What form do you use? Most people who do this work will be familiar with the fact that there are 2 forms, the form 1290 or the form 1300T. So the 1300 form, which is what we call it, is the standard form. And that's the form that most people will be using when they apply. Importantly, I'm using the word form, but in fact, everybody must now apply online. And so they won't actually use the paper form unless they're applying for an exemption. Again, I'll cover that a little bit later. But for your standard applicant, someone between 18 and 59 years of age is going to sit the test, who's been here for 4 years. They'll apply online through an IMI account, and they will notionally use that form 1300. Those forms are still available, and so often what I will get clients to do, if I'm going to help them apply online, because it is tricky, is get them to fill out all of the information on the paper form, then sit next to them with the form and the client, get online, create an IMI account for them if they don't have one, and then input the data that way. Even if you are using a paper form, and you can use a paper form if you're eligible to pay a reduced fee, again, something I'll talk about later, you still have to pay for the application online. That means you need an IMI account. So all of the clients who apply, whether they're using the paper form because they're eligible for a reduced fee or an exemption, or they're not using the paper form, they will still need an IMI account because you need to at least pay for the application fee. You get a receipt number once you've paid, and then that receipt number is physically written on the paper form that you're able to use. So everybody needs an IMI account, basically. That's the long and the short of it to apply for citizenship. The form 1290 is the form used for anyone who is not sitting the test, and therefore applying and then getting a reduced fee, paying a reduced fee, either because they're 60 or over, they're under 18, or they have a disability. So they're the people who are not sitting a test, and we call that they've got an exemption from the citizenship test. That's a lot of the work that we do in the area of citizenship. I'm going to talk about that quite substantially later on in the presentation, about the kinds of exemptions that you can get, when your client might be able to get an exemption from sitting the test, and when they most definitely are not going to. Okay, so you know the process. You're convinced that the client's able to apply, they've been here for the 4 years, you've decided what form that the client's going to use. Then you need to decide who can be included on an application. Often families will think that they all apply together, like they've applied for their visas together. So you'll have the primary applicant, usually dad, and then there's mum, and then there's the kids, and so everybody will apply together. Again, people who work in this area will know that's not the case at all. All adults must do separate applications, and pay a separate fee. You can include children in an application, but only if they are under 16. So basically that means if they are 15 and under, they must be and should be included in the application of a parent, and they're free. If they're included with the parent, there's no charge. If they're 16 or 17, so still not 18, so still not adults, they still have to do their own application and pay their own fee, which is cheaper than the standard adult application, but nonetheless, they will have to do their own separate application to mum and dad, who are also doing their own separate applications, and pay a fee themselves. If they're 18 and over, they just apply as adults. So even if they're at school, even if they're living with their parents, even if they're otherwise dependent on their parents, doesn't matter, they all have to do their own application form online and pay, really critically, their own application fee. One thing that I want to note about including children on applications is who do you choose? Do you choose mum or do you choose dad? And mostly this is just not a choice, or it is a choice, but it's random. If you are including children on the application of one of the parents, you should include them on the application of the parent who speaks better English. And that's because if the parents are both having to do the citizenship test, again, we'll speak about who has to do it later, and the parent fails, one of the parents fails the test, and that parent has the children included on their application, all the children will be refused as well. So the parent is refused because he or she has failed the citizenship test, and the children will automatically be refused as well. So when you're applying, think, okay, is dad at this point in time? It might change, of course, but at this moment in time, is dad the better English speaker? Okay, let's include the kids on dad's application. If it's mum, then they should be included on mum's application. One thing I'll note, and it's somewhat complicated and we can certainly help people with this, is you can actually transfer children to the application of the other parent if the clients have applied, kids are on dad's, mum's a better English speaker, you know that mum's better and she's more likely to pass the test. You can apply to have the children transferred to mum's application. So that's really something to keep in mind. And if you've got clients where you think they might need some help with that, we can do that for them. Okay, cost. This is a really big one. I'll say from the get-go that because it's complicated, Bridget referred to a fact sheet that you can download from the control panel, and that is on what forms you use for people and what cost applies to a person. So you can see on the screen there are 4 numbers. The cost of the application is going to be one of those numbers. So you can see it goes from $4.90 to $35. The cost depends on a number of factors: the age of the person, whether they have a disability, whether they'll do the citizenship test, whether they have a pensioner concession card, not to be confused with a healthcare concession card, which everyone on Centrelink has, and often people trip up on that. A pensioner concession card is given to people who receive certain types of Centrelink benefits, including the age pension, so people who are either 65 or 67, depending on male or female, the DSP, which applies to some of our clients, the disability support pension, or the carer's pension. So if they get one of those benefits, they will have a thing called a pensioner concession card. Not everybody has the health concession card. If you've got a pensioner concession card, it's much cheaper. In terms of the standard fee, that's for people who are between the ages of 18 and 59 who will sit the test. That is $490. Okay, that's the fee that will apply to most of our clients. So 18 to 59 will sit the test because they can't get an exemption from the test, don't have a pensioner concession card. They're going to pay $490. So remember that's for each adult. So if you've got mum, dad, and an 18-year-old, and they're all under 59, and they're all going to sit the test, that's $400. That's, it's almost $1,500 for 3 people. Just in terms of some other examples, and I won't go through all of the examples because it does get complicated, but all of this is on the fact sheet, which I'd encourage you to download, because it's a bit of a ready reckoner. It gives you, the circumstances of the client, the form you use, and the fee. Just as an example, so people who are over 60, they don't have to do the test, but some of them have a pensioner concession card and some of them don't. So those who do have a pensioner concession card, the cost is $35. If they're over 60 and they won't sit the test, but they don't have a pensioner concession card, the cost is $300. So it's worthwhile getting this right. If you make a mistake, you or the client makes a mistake and you pay either too little or too much, which happened to me recently, even though I was assisting the client because I didn't know she had a pensioner concession card, then immigration will, God bless them, they will let you know that you've paid too much, and they will notify the client and say, oh, we're going to send you your money back because you paid too much. Equally, if you haven't paid enough, they will write to you and ask you to pay the additional amount. Although the application, strictly speaking, is not valid without the proper fee being paid, they don't seem to worry about that too much. So it's not a catastrophe if you don't pay the right fee. Immigration will get onto that and they will let you and the client know, and then you either get the refund or you pay the additional amount and off you go. Look, that's probably all I'll say about the cost. It is complicated, but I think the thing to hold on to is that if you're an adult, the fee is $4.90. If you've got a pensioner concession card, it's substantially less. If you're just on Centrelink, but you don't have a pensioner concession card, you still have to pay the full fee, and sometimes that's an issue for our clients. They think, well, if I'm on Centrelink, then surely there's a reduction. There's not. The one other thing to note that for children who are, because I said earlier, if you've got kids who are 16 or 17, also have to make their own application. The fee for them is $300, not $4.90. So it's kind of like an adult application, but it's not really because they're not 18, and that fee is $300. So that's the $300 one that's up on the screen. Okay, that's a lot of information. What I thought we'd do, just so we can try and kind of consolidate a little bit what I've been talking about for almost half an hour now, is just kind of put this to you. This is a pretty standard scenario. The client's married. I'll just read it out, and then we'll ask you we'll give you some multiple choice answers and see how you go with those. Your client's married with 4 children, age 16, 9, 6, and 3. So 4 kids, one of them 16. She's been in Australia since 2017 with her family. Her husband works and he speaks very good English. She is 37, her husband's 45. The client doesn't work, but she goes to English lessons, and she also gets parenting payment for the children, and she has a healthcare concession card. So, Bridget, will those questions come up now? Here you go. The first question is, how many families, based on that scenario, will the family need, how many applications will the family need to lodge? So there's mum, there's dad, there's 4 kids under 15, and there's one who's 16. How many of you do you think
to let people know, you can click on your screen to choose the answer.
Like even I can do that, but I won't.
Okay, it looks like everybody's answered, so I'll close that off and share the results.
What do we got? Perfect. Actually, absolutely right. Thank you. 1 for dad, 1 for mum, and 1 for the 16-year-old. Okay, next question. Which application should the children be included on? So there's mum, there's dad, or they should all do a separate application for each child. So each of the children, so that would be 4 applications plus mum and dad.
Okay, everyone's responded, so we'll just share the results.
Yes, dad. So dad, because the scenario told us that he speaks better English than mum. And as I said earlier, if they both have to do the test, which on the current facts they will have to do their test, and mum's English is not so good, she might fail the test, and if she fails, the children fail again. And there's nothing that you can do except apply again for the kids. And once dad's got his citizenship, of course, he's done. So they can't be included on dad's application. They have to just wait until mum's English improves to the point where she will pass. Now the kids, in the scenario, one was 16, so he or she will apply separately. But the 9, 6 and 3-year-old, they can't actually do anything. They can't make separate applications until they're 16. So it's really important that mum actually passes the test. If she gets to a point where she's, if she's not able to and dad's already been granted citizenship, the kids could wait. The 3-year-old, will have to wait 12 years until he or she could make their own application. So obviously you want to avoid that kind of situation. There's no way a child can apply separately just because their parent can't pass the test. So it's something to actually think about when you're thinking about where the children should be included and whose application. One more thing I'll just remind you of is if this is an issue for any of your clients that you know about, you can transfer them to the application of the other parent who applied at the same time. If that's a thing, and you all know how to, I think everybody probably knows how to contact the Refugee Service. Our details are at the end anyway. Send us an email, we'll book the client in and we'll help them if we need to try and transfer children from one application to another. Okay. Excellent. The next question is, this could be difficult because I'm not sure I covered everything. The next question is, what will be the total cost of the applications? So we've established that we need 3 applications, one for mum, one for dad, and one for the 16-year-old. What do you think? How much is it going to cost this family in total? It's a big whack of money.
Just give people a little bit longer.
Yeah, no worries. I had to do the maths too. It was pretty simple maths, but I did get my calculator out on the phone.
Share the results.
Yes, 1,280. That's it. Perfect. So that's 490 for dad, 490 for mum, and 1 separate application for the 16-year-old, and that's $300. So that's $1,280, which is an enormous amount of money for our clients, just enormous. This doesn't add anything to anything, it's more of a complaint, but up until last July, so July 2021, the application fee, the maximum that you would pay was, I think, either $290 or $295. And then on 1 July last year, it went up to $490. So an increase of almost 75% for your standard citizenship application. Even though we've now got a new government, it's unlikely to come down. Our Home Affairs said at the time, well, that covers some of the cost of processing applications, which, anyway, that's that. Unless you've got a pensioner concession card and you're not going to do the test, the cheapest that you'll pay, even if you've got a disability and you're not doing the test, if you don't have a pensioner concession card, it's still $300. So it's still very expensive. Okay, that's the questions. So talking about the test, we're going to move on to the test itself now. There you go. Most people, as I've been saying, will need to do the citizenship test. There are some exceptions to that, and I'm going to speak about those later at length. Broadly, it's not an English test per se, but the test has to be done in English. So it kind of acts as an English test. About 5 years ago, thereabouts 4, 5, 6 years ago, the test was the same. There was a test that was introduced many years ago when John Howard was Prime Minister. And you could do the test in your language of choice. So the pass rate was much higher. About 5 years ago, it changed, and they decided that they would make it compulsory to do the test in English. So even though it's not, they say it's not an English test, actually it's really an English test. The pass mark is not 50%, it's 75%. And there are 20 questions in total. Fairly recently, I think maybe 2 years ago, the test changed and they included 5 multiple choice questions. They're all multiple choice, all the questions, but they included questions about what they call they, Home Affairs, Australian values. And those questions address things like mutual respect, equality, democracy. You have to pass, so your clients have to pass all 5 of those Australian value questions. And so then there's 5 Australian value questions, 15 other general questions, and in total, you have to get 75%. So get the 5 value questions right, and then you probably have to get, I tried to do this calculation, I think you have to get 12 of the 15 right. So it's pretty hard to pass. And just because it's fun, we're going to do some of the questions later on, just to see how you all go. If the client, as I said, the test has to be done in English, but if your client can speak English but can't read it, they can actually ask for someone to read the questions out to them. It's a special sort of exemption that you have to get. In order to get that exemption, the client has to prove that they have completed 400 hours of AMEP classes. So that is, they have to prove, so they get a letter from their AMEP provider, their English lessons provider. That's different people in different places, Max Solutions in some places, TAFE in other places, Navitas in other places. And that letter has to say, yes, the client has diligently attended, they've done their 400 hours, and despite the fact that they've done their 400 hours, they still don't speak adequate English. The basis of that is, that Home Affairs say, well, look, if people have tried and they've done their best and they've done their 400 hours and they still have this certification from their English lessons provider that they just aren't able to read English, but they can speak and understand pretty well, then we will give them this tiny, with this tiny benefit, which is there'll be a Home Affairs officer who will literally sit next to them in the testing room and read the questions out to the client in English. Obviously, they won't assist them. In terms of the number of times you can do the test, there's no rules about that. And in theory, you can do it as many times as it takes to pass. I've had one client who he was allowed to do it, I can't quite remember, it was something like 22 times before, this is last year, finally somebody at Home Affairs said, no, he's not going to pass, and they refused him. I've never seen that before. More often than not, you'll get Home Affairs. Home Affairs will give the client roughly about 3 chances to sit the test. If they keep failing, then the application ultimately will be refused, and all they can do then is apply again. In theory, again, you can appeal decisions, you can appeal refusals, but if a person has been refused because they failed the test, there is no utility, there's no point at all in making an application for an appeal. All they can do is apply again, and of course all we do is encourage them to improve their English between that new application and the time they'll sit the test again. So just to be clear, there's no strict time, there's no strict number of times. The law doesn't say 3 times and you're out, and it seems to be discretionary. And so when people ask us, well, look, I've failed twice, do you think, or I've failed 3 times, what will happen next? And the answer is, we don't really know. The next thing might be you get a letter saying you've been refused and you'll have to start again. Of course, including, paying the fee again. And sometimes they might all of a sudden, and pretty surprisingly, get an invitation to sit the test again. Okay, so that's for people who have to sit the test, and that's going to be most of our clients, despite them thinking and saying to you and to us, I'm going to get I need an exemption. I'm going to tell you why I need an exemption. let's all try and apply for an exemption. That is very difficult to apply for and get, and I'm going to talk about exemptions now and the kinds of times and places and scenarios where people might be able to get an exemption. Before we do that, as I said earlier, I extracted a few questions from the Home Affairs website yesterday, because you can do practice tests online, and I extracted a few of them, a few of the Australian values questions, and I got one of them wrong, and then I tested out one of the other questions, a non-values question, on my children. They're both at university. They both got it wrong as well. So I just thought it was fun, actually. So why don't we just go to the first poll question, which is, this is one of the values questions that Home Affairs like to ask people. Should people in Australia make an effort to learn English? I got this one wrong. You can see what the options are there. There's no
because of a character limit, I did abbreviate that first.
No worries. Okay.
Possible answer.
That's fine. Well, that pretty much captures it anyway. But let me just read out. This is what appears on the Home Affairs website in a practice test. So, should people in Australia make an effort to learn English? The first option is people in Australia should speak whichever language is most commonly spoken in their local neighbourhood. The next option is there is no expectation to learn any particular language in Australia. And the third option was yes, English is the national language of Australia, and it helps to get an education, a job, and to integrate into the community. So which do you think is the right answer? I'm probably giving it away a bit, because I think I told you I failed it. That's true. That's correct. Yes, English is the national language of Australia. I probably very naively said there's no expectation to learn any particular language in Australia. So that's a values question. That was the first one, but you're correct. The correct answer is yes, English is the national language. The next question is also a values question. See if you can get this one. Which of these is an example of freedom of speech? And that's exactly actually on the screen, is exactly as the questions appear on the Home Affairs practice test. I got this one right, fortunately. What do you reckon?
Just some more responses coming through. I'll close it off in a minute.
Oh, good. Oh, good. No, have a think about it. Because it's like you do have to think about these things, you know, even for us. I mean, you have to think, all of those things apply, but what's the right answer here? It's correct. So most people answered correctly. People can peacefully protest against a government action. And when I say correctly, I mean according to the Department of Home Affairs, that's the most correct answer. It's also true that men and women are treated equally in a court of law, and it's also true that Australians are free to not follow a religion. But what the question asks for, and this is why seemingly easy questions are actually much more difficult, what the question is asking for, what's an example of freedom of speech? And so you can see how easily our clients could get tripped up on things like this. We'll go to the last question. So those two were values questions. The next is a non-values questions, but it just gives you an idea of the flavour of the questions will be asked in English, of course. What is a referendum? My children didn't know this. They're both university students who grew up in Australia speaking English.
Okay, everyone was
What do we got?
faster responding to that. We'll just share the answers.
That's very good. Vote to change the Australian Constitution. Well done. That's right. So vote to change the Australian Constitution. They don't happen very often, and I don't think there's been a successful referendum in over 100 years. Yeah, that's right. So that just again is just to give you a vote to change the government. I think we all would have started our own referendum. prior to Saturday. Sorry, I shouldn't have said that. So that's right. It's a vote to change the Australian Constitution. Doesn't happen very often, but I mean, for me, I think that's a difficult question as well. And of course, these, you probably all know this, but if you don't, it's useful to tell the clients, that they need to go online and keep practicing. And you get 20 questions and you practice, and then you can practice again. And eventually, I assume that if you practice as many times as you possibly can, you would actually come across each and every question. I don't know how many questions there are to choose from. It's something huge, though, like 300 or something. Anyway, there's a range of about 300 questions. Anyway, it's a very large number, and of those, randomly, 20 will be selected for your clients when they sit down to do their test. Okay, well, that's interesting. Okay, this is what everybody really wants to talk about when they call us and they want immigration and they want citizenship advice. It's almost always about getting an exemption from the test. And so getting an exemption from the test means this. You get an exemption and you don't have to do the citizenship test. And if you think back to the process, the application process, which I think was the first slide, the test is right in the middle there. You do the application, you do the interview, there's a test, and then there's a ceremony, and then there you go, you're a citizen. And this is, of course, the test is, this is where a lot of our clients have difficulty. And that's why many of them want to talk about getting an exemption. Okay, so there's a few categories and I'm going to go through them. The first is 60 and over. So the first, if you are 60 and over, then you do not have to do the test. I often will say to clients, if they're close to 60, and sometimes that's even 58, but almost 59, and they're concerned about doing the test, given how long it's going to take to get to the point where they do the test anyway, if they think that they're going to fail, sometimes I'll say, look, maybe just wait until you're 60 and then lodge your application. I think that's a real option for some people and something that we should talk to our clients about. Applications where the person doesn't have to do the test, generally, including for people who are 60 and over, this is actually mostly the people who are 60 and over, are often processed more quickly too. Firstly, because there's one less step in the process for them to complete. And apart from going to the interview, everything can be done what we call on the papers. So as long as the person's identity has been confirmed, as long as they have established that they're 60 and over, as long as they've proved that they've been here for 4 years or more, that's it really. That's all they need to establish. So it's a pretty easy process, and because it's easy, it tends to happen more quickly. Also something to take into account, if your client is 59, worried about doing the test, you're thinking perhaps they won't pass again, maybe wait till they turn 60 and then put the application in. It's also cheaper. It goes down to $300 from $490. So also another reason to wait. One thing I would say about the 60 and over people, even though they don't have to do the test, they do have to do an interview. Everybody has to go for an interview. And at that interview, they'll be asked if they understand the nature of the application, what it means to be a citizen, and all of this will be conducted in English. Home Affairs say if they don't understand enough English to have that simple conversation, then they the applicant, will need to pay for their own interpreter, because Home Affairs won't provide that. They can also, and I think this is what most of our clients will do, just take someone with them to help them with that process who is not an accredited interpreter, like a family member or a friend, but that person must speak English very well. So it's not a formal interview such that you have to have a NAATI accredited interpreter, but the immigration policy says, if you come along for an interview, we're not paying for an interpreter, which is how I can say with certainty it's not a formal interview, because if it were, Home Affairs it would be incumbent on them to make available an interpreter. But they do say, if you're worried, bring your own interpreter, you can pay for them, or bring a family member with you to interpret. So they will have to go for an interview. I'll just make that point. 16 over. The next category of people who are exempt from sitting the test are people under 18. So if a child is 16 or 17, as I've already said, they'll have to lodge their own application, but they do not have to sit the test. If a child is 15 or under, again, they'll be included on one of their parents' applications. The parent will have to sit the test. None of the children will have to sit the test. And again, I make this point that if their parent fails the test and the application is refused, then the child will also be refused. So under 18 also don't have to do a test, even if their English is perfect, and more often than not, if they've been here for a bit, it is, but they don't have to do the test. The next category of people who might be exempt from sitting the test are those people who have a disability. So a disability might be a physical disability, or it might be a mental health condition, like a mental disability. And under this umbrella of disability, there are three main categories, which I'll go through now and slowly. I'd say broadly for all of these, the most important part of the application is the medical evidence that you have to support the claim for an exemption from the test. And this is where most of our clients will fail. Not so much because they don't have the disability that they're claiming, but that they don't have evidence of that disability or appropriate acceptable evidence of that disability. The policy that the department has about medical evidence is very, very strict. And so if you get a report from a doctor, for instance, who's not qualified in the way that the policy says they need to be, then the client won't get the exemption. Again, even if it's abundantly obvious that the client has the disability, if the evidence is not in the exact form that the policy calls for, they'll likely get refused. I'll give you some examples of the qualifications medical professionals need if they're going to report as we go through a bit more. So the first category of people who can get an exemption from sitting the test, and these are the kind of the easy ones: hearing, speech, or sight impairment. So you can ask for an exemption from sitting the test if you are suffering from this is what the law says, permanent loss or substantial impairment of hearing, speech, or sight at the time they make the application. So those terms that I've just read out, permanent loss or substantial impairment, they're not defined in the Act, in the law. So they're just given their common meaning. I have a couple of clients, a number actually, who have hearing impediments. So they wear hearing aids. Their hearing is, it's permanent. It's not absolute in both ears, but I've argued that they have a substantial impairment, and I've just based that on common usage of that, the common meaning of that term. What does that mean? I haven't got a result on any of those applications yet, but I feel pretty confident that if you can argue that a person has, and it's pretty easy for hearing because they actually measure things, and so you'll actually get a graph that looks, that looks like a graph, and it's like it says 50% or 70% or 90% loss of hearing, and so that's kind of easy. You go, okay, this person has 50% loss of hearing in this ear. I'm going to argue that that's a substantial impairment. So they're not too difficult to get over the line if you've got the right evidence. And again, that's what I'm going to talk about now, the kind of evidence, because this again is where clients will often fail because they have the impairment or the condition, they just don't have the evidence of it. So let's start with hearing and acceptable evidence. So has to be a certified audiologist or evidence that the client's registered. This is obscure, none of my clients ever have been, is registered with the Office of Hearing Services and has complex rehabilitation needs. This is all from the policy of the Department of Immigration. It's nowhere in the law, but it's in the policy, and I can tell you that the decision makers follow this slavishly. They never deviate from it. So if you don't come within the policy, it's going to be really hard for your client to get over the line. Even if you've got, say, you've got a letter from a person who's not a qualified audiologist, there's another kind of clinical qualification, which is not quite audiologist, and it's one down, audiometrist or something like that. Hearing Australia, which is a place that has provided me with lots of these reports. They employ people who are not qualified audiologists but can do all of the tests and write all of the reports. Those reports are not acceptable, even though they will say everything that they need to say about a person having a substantial impairment. If the report is not from the audiologist, then it won't get over the line. The report has to give some information about the degree of the loss, so the hearing loss, the length of time that the person has suffered the loss, and whether the person uses hearing aids to assist them to function in the community. That's all it really needs to say. It doesn't need to say because they can't hear very well, they can't learn English. It doesn't need to address those normal tests about exemptions that we'll talk about later. It's just like, does this person have a hearing loss? Is it permanent or is it substantial? Do they use hearing aids? That's it. And once you've got that, and usually it's a one-pager, send that in with the application and I think you'll get over the line. The next is speech. So if a person has a substantial impairment of speech, they need to provide a report from their treating doctor. And that's all the policy says. Treating doctor, could be anybody, could be your GP. Again, it's not particular. If you've got a speech pathologist or a speech therapist, probably better. But all they need to do is prove that they have a permanent loss or a substantial impairment of speech. Again, what does that mean? I mean a whole bunch of things to a whole different range of people. So I think if you know any clients where that might apply, the thing to do is get the letter from the doctor or the pathologist or the speech therapist, send it to us, we'll have a look and say, yeah, it looks like it complies with the policy, you should have a go on that. The next is sight. So remember it was hearing, speech or sight. So this is one particular category of disability. Sight is, again, you have to establish that there's a permanent loss or substantial impairment of sight, and whether or not the person uses aids to get around the community. So sometimes they might have a cane, they might use a cane or a seeing eye dog or something like that. You just need a report from an ophthalmologist who is a fellow of the Royal Australian College. This comes up a lot. And also a recent report from an optometrist. Recent is not defined. We don't know what that means. It just says recent. We'd always think probably within the last 6 months. If people have a static condition, that is a condition that they've had for a long time, it's not getting either better or worse, then the letter from the ophthalmologist would say, this person's lost their sight 10 years ago, they've been blind since birth, it's not better, it's not worse. Recent could mean anything really. It doesn't add anything. I've had clients again who have been blind from birth, and we got a letter that said that, and that got us over the line on that one as well. You don't have to prove that somehow because of this sight impairment, again, this is with the hearing and speech, they can't do the test or they can't learn English. You don't have to prove that. That is different for other disabilities, which we'll speak about soon. For these, the sight, the hearing, the speech, you don't have to prove that has any impact on the way that they learn or remember or take in information or convey information. It doesn't matter. Because as we know, people with speech or sight or hearing impediments can get around in the world. They can learn English, they can read, they can do all of the things that you and I do. But Home Affairs have said, as long as you can prove that you have one of these conditions, that's enough for us. The next is physical incapacity. This doesn't come up very often, actually. So this is the second category of people, the first being the hearing, the speech and the sight. The second is for people who have a permanent physical incapacity. This is different to the hearing, speech and sight tests because for a physical disability or physical incapacity, you have to prove that because of your physical incapacity, you can't understand the nature of a citizenship application or you can't learn basic English, or you don't understand or can't understand the responsibilities of being an Australian citizen. So this really goes to your cognition, like what can you understand or not understand because of your physical incapacity. For that reason, this doesn't, like when you look at it, you think, oh, it probably applies to somebody who's paraplegic or somebody who uses aids to walk or somebody who is an amputee, you know, somebody who's lost a limb. It actually doesn't, because all of those things will not impact on how you learn. And the only thing that we've ever seen in the Refugee Service that I can think of is maybe a person who has suffered a brain injury. So that's a physical injury and it's a physical condition, and it impacts on the way that they learn and think and behave and communicate, and that's what you have to prove. So there has to be a link between my physical incapacity and my ability to understand the nature of citizenship. And if you can't make that link, and I can't think of any other examples where you would be able to make that link except a brain injury, then you're not going to get over the line on an exemption from the test, and you'll have to do the test. Just briefly, physical accepted evidence. You have to have a report, an acceptable report from a person who practices in the area that your client has, in the area of medicine that your client needs, that specialist. So I didn't put that very well, but basically, you know, it would be if it's a person who has a brain injury, it might be a neurologist. If it's from a support, if it's from a report, if a report's from someone without this accreditation, and this is all through the policy for exemptions, everybody has to be properly accredited, then it just won't be accepted. Even if, again, the content of the report actually proves that the person has this disability, and even if it says because of this disability they can't learn or they don't understand or they'll never be able to do the test, even if it says everything it needs to say, it's not from someone with the appropriate accreditation, it won't be accepted and the client will be refused. Okay, this is the third and last category of people who want to apply for an exemption from the test. And this is for people who have a permanent or enduring mental incapacity. That's the words of the law. And this is the category that most of our clients will fall into, definitely. Most, if not all, of our clients would have, not all, you know, many of our clients would have, they come from torture trauma backgrounds, they might have depression, they might have PTSD, they might have a whole range of conditions that haven't otherwise been diagnosed. And so this is where the exemptions come up a lot for our clients, this category. So as I say, you have to prove that the client has a permanent or enduring mental incapacity. So what's enduring? Basically, it's long-term. It doesn't have to be permanent, but it might be something that is very long-term, and it's so long-term that it would be unreasonable to expect the person to wait until they've recovered before they can apply. So it doesn't have to be something that's permanent. So it can be something that you know, might get better, but you know, after lots of therapy and lots of intervention. And so the report that you get would have to say that, look, this is depression, it's very severe. We expect that we can make some real inroads in terms of the treatment of this client, but we know that they've been suffering with this for 4, 5, 6, 10 years. It's going to be a really long process. So it doesn't have to be permanent, but it has to address, well, how long has it been? And do you expect it will get better? I touched on this with the physical incapacity, in the physical incapacity category. This is the most critical part, alongside getting an accredited specialist to write the report. It's not enough to establish that the person has a mental health condition. And we too often see reports that say this person has depression, has PTSD, has this, or has anxiety, has panic attacks, therefore they should not do the test. Critically, you have to show that as a direct result of that mental health condition, they're not capable of understanding the nature of the application, the citizenship application, like what it means to be a citizen. And really, this is where it comes down to, they're not capable of demonstrating a basic knowledge of English. So that is the critical link. The report has to say this person has this condition, and because of this condition, which is either long-term or permanent, they cannot sit the test because this is the common one. They just don't have the ability to learn English because they are so impaired that they are never going to be able to concentrate for long enough to remember, like their memory might be impaired because of their mental health condition. They can't remember things. They can't take things in. Information floats over the top of them. And the reason that happens is because of their mental health condition. So there has to be a direct link written in the report in very stark terms. This is why they should be exempt. Short-term mental health conditions, or those that, short-term, or unfortunately, some of the conditions that are suffered by our clients would be said to be short-term, and so depression is a big one. If they haven't been treated and they just go to their GP occasionally and they're on medication, say, that's not going to be anywhere close enough to get them over the line for an exemption. It's also not enough to say, as often it happens with the clients, well, I'm on the disability support pension, so I've been assessed as being, impaired enough so that I don't have to look for work. The immigration policy specifically says that's not going to be enough to get an exemption from the citizenship test. They're very different tests. So it's not enough to say, here, the client's got depression, they've got the DSP, which is hard in itself, therefore, they're going to get an exemption. That's also not going to be enough to get them over the line. So I've just covered what the report has to say. This is where it must come from. So we're talking again about clients with mental health conditions. So the obvious specialist that we're looking at is a psychiatrist. Many of our clients who live in rural and regional areas in particular, they just don't have the access to a psychiatrist in the way that we might in the city, although even in the city it's very difficult. And so the policy does say, if you live in a regional area, we can accept a report from a general practitioner in some limited circumstances. So that's something to keep in mind. If you're in a regional area and your client's in a regional area and there's one psychiatrist who flies in once every 3 months and there's a wait list of 2 years to see them, then you might want to be thinking about, well, how else can I get this person over the line? I think that they do have a condition that really impairs them. It's just a question of getting a report. On that, and on the issue of, people seeing psychiatrists, but only intermittently, policy also says, and again, this is very important, that generally speaking, just seeing a psychiatrist once and getting a report from a psychiatrist is not going to be enough. It's not enough just to have your client see a psychiatrist for an hour or two, get a report that says seemingly all of the right things. Home Affairs will have a problem with that as well. When that happens, and it does happen fairly regularly, just because it's an issue about access, people don't have access, they can't afford them, there aren't enough psychiatrists. What we will generally do is say, yep, they've only seen this psychiatrist once. That's because they can't afford to see them regularly, or they just simply don't have access, or they live regionally or remotely, but they see their GP once a month or once every 2 weeks. And the GP, although the GP's report isn't acceptable evidence, kind of provides a background evidence that can support the report of the psychiatrist. So you say, look, here's the report from the GP that says, I diagnosed this person with very severe depression, panic attacks, anxiety, PTSD, social anxiety 4 years ago. I treat them with this. They also see a psychiatrist intermittently when they can. There are access issues. If you have that, I think that is very arguable, and you would have to write a submission about that and argue with the department about that. But I guess what I want people to understand is, if your clients have no access to a psychiatrist, to treat them, and it is unlikely they will ever have access to a psychiatrist to treat them, then there are other ways that you can try and get around this policy. So something to keep in mind. The reports for this category of incapacity have to be very, very fulsome. How long the specialist has been treating them, that goes to how often do we see them, how often have I seen them, whether interpreter is used, they have to undertake testing. So Home Affairs are now saying we want people to do cognitive or clinical testing, the date of diagnosis, the basis of the diagnosis, the severity. These reports are very long usually and also extremely expensive. You know, it can be $2,000, $3,000, $4,000 if you get a big long one. That's also an issue of access, and also something that we try to use in our submissions when we say, yeah, they've seen a psychiatrist, they saw them once on Medicare, they can't afford, they don't have access, that's one issue. The other is a question of cost. And so these are all things that you can argue about with the department, but overlaying all of that is that you must have, you have to have some really strong evidence about the person's mental health condition, and it's simply and that condition being the reason why they can't do the test. They have to be linked. That's the really critical part. Okay, so alrighty, I think that's enough talking for a minute anyway. I'll get back to talking soon. But to give you all a bit of a break to hear me talking, we're just going to do some poll questions based on some of the scenarios that we've just some of the issues that I've just covered. And these are about, does this person have to do a test or not? So they're pretty simple ones, just to, if you can turn your mind to them. So the first question is, it'll be coming up on the screen soon, or I can just read it out.
I'll put it on the screen, but is there a bit of a scenario that you read first and then there's a question about the scenario?
No, it's really just about the scenarios are this. So these are, does my client have to do the test?
Okay.
So your client is 62, speaks, reads and writes perfect English. Does she have to do the test? Based on what you've just heard me talk about.
Okay, I think everybody's answered that, so I'll just share the results.
That would be a big no. Yep, because she's over 60. Oh, bless the person who said she can do it if she wants to. She can do the practice test if she wants to, but they won't let her do the test even if she really wants to. No, she doesn't have to. She's over 60. So that's a no. She doesn't have to, and she can't even if she'd like to. The next one is, this is quite long. Bridget, I might need to read this out.
Yeah, you will.
Yeah.
I've included a question, but yes, I think this is the one I was thinking of.
Okay. All right. So let me read the question out because it's quite long, and you've got the options there that make no sense until I do. Your client is 35. He has a diagnosis of severe depression. He doesn't work and he gets the DSP and recently stopped going to his English classes because he didn't get on with the other students and he had no friends there. He did do 200 hours of English lessons though before he stopped. Will he have to do the test?
I think they've all been listening closely because there's some more people responding now. There were a lot of responses, but more people are responding now.
Okay. Slightly tricky. And
okay, I'll close that off. I'll close that off now.
No worries. Just say maybe. Yeah, look, frankly, maybe is the right answer. Yeah, if he can get evidence that the reason he can no longer attend class and therefore improve his English, you remember I said it's not really an English test, but it sort of is. If the reason he can't improve his English is because of his mental health condition, then he won't need to do the test. If he just doesn't like going because he doesn't like it there, that happens. That's not going to be enough. You can't just say, oh, I've stopped going because I don't like it and I've got no friends, but hey, I've also got very severe depression and I get the DSP. That isn't going to be enough. There's going to have to be medical evidence that says he stopped going because of his mental health condition, not because he was unhappy in class. So that's the answer to that, basically. Okay. Citizenship problems. I'm so conscious of the time, so I'm going to have to almost rush through this. I thought I had loads of time and now I have none. Citizenship problems. So these are, I'm going to just profile the two major problems that we see with our clients. And the first one is identity issues and the second is character. So the first one, identity. Identity issues are a huge problem for clients in some communities in particular, and they are the communities that often have not arrived with any ID documents, often have never had any ID documents, and have sometimes been living outside their home country for many, many years, sometimes decades. This affects in particular people from Myanmar or Burma, because they are often minorities who have been living usually in Malaysia or Thailand for many, many years. They weren't registered at birth. They have no documents from their home country, and they arrive here with nothing. They have a lot of ID issues, and the ID, when I say ID issues, what I mean is they are not able to prove who they are to the satisfaction of immigration. Also an issue for some of our Afghan clients. ID tends not to be an issue for clients from the Middle East. They all seem to be very well documented. They have birth certificates, they have passports, national identity cards. So this issue of identity doesn't often arise for them. Look, broadly speaking, if you can't prove who you are, then you won't get citizenship. If you can't prove who you are, and something comes out in your citizenship application that's different from information that the client gave when they applied for their visa, then that's also problematic. It becomes about identity, but also becomes about character, which I'll talk about in a moment. You have to be really, really careful with identity issues in particular about not saying anything in your citizenship application that's inconsistent with anything that you've said in your visa application. That's really problematic for most of our clients because they often don't remember what they said, or more often they didn't fill out the application form. Somebody helped them, someone overseas helped them. They actually don't know what's in there. So if you think that this is an issue, a client comes to you and they say, look, I don't have any, what we call them feeder documents, any source documents from my home country. The first thing that I say to clients is, okay, let's get a copy of your visa application file, because you've said that you don't have any of those documents, but you also don't remember whether you might have given somebody a document, like it might have been a document from the UN, for instance. It might not have been a birth certificate or a marriage certificate, but it might have been some document that we can work on. Get a copy of their visa application file before you start the process of citizenship. And sometimes, lo and behold, on that file, there'll be a document that you can use. So that's the first, pardon me, that's the first thing I'd say about ID. If somebody comes to you, they have no ID documents, first thing you do before you even think about going and applying for citizenship, FOI, their visa application. Okay? It's important to remember, because sometimes clients come to you and say, look, I don't have any of those documents, but I have a driver's license. I have a Medicare card. I have my ME card. They should be included, but they are not anywhere near enough to prove a person's identity, because they are all documents that flow from the one document, which is an ME card. So people come into Australia, they've got their visa, they've got their ME card. On the basis of their ME card, they get their driver's license. They enroll their kids in school. They they rent a house. They get a Medicare card. That doesn't prove who they are. Doesn't prove who they were before they came to Australia, and that's the critical thing. Even though they've proven their identity to the extent that they've been given a visa, and so clients will say, but they know who I am because they gave me a visa. What Home Affairs say about that is, look, Giving you a visa is one thing. We're prepared to be a bit flexible about identity, particularly because we're giving you a refugee visa. So we should be prepared to be flexible around issues of identity and documentation. Giving you citizenship is a whole new ballgame. Like, that's serious stuff. If we give you citizenship, that is something that is serious, that is permanent, that is enduring. We need to be absolutely certain that you are the person that you say you are. So people are in a bit of a bind. They've applied for a visa. They don't have any ID documents. They didn't have any when they applied. They got their visa. They come here and then Home Affairs say, well, where are all your identity documents? And they say, well, we don't have any. If that is the case, Home Affairs will write to the client. So let's assume the client puts in the application with the ID documents they have, which are not very often, not many. Home Affairs will write to them and say, we don't know who you are. If you can't provide any documents from your home country that prove who you are, firstly, tell us why you can't provide those documents. And secondly, we're going to ask you to write your life story. And that's exactly what it's called in the immigration policy. It says your client must tell us their life story. And it's basically, it is as it sounds, it's a story of their life. And it has to be given in as minute detail as your client can possibly muster, starting with, I was born here on this day in this village in Myanmar. I have 6 siblings and their names are this, 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 and they were born on this, 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 or I don't know when they were born. And then their education, their work, how they left their home country, what they did after they left, or where they lived, how they supported themselves, if they got married, when they had kids. This life story is basically, it's an alternative to ID documents. And what Home Affairs will do is say, okay, look, this looks like, this is a lot of detail here. Like, this doesn't look like it could be made up. Now, that's not a fail-safe way of judging somebody's identity, but it's the best that Home Affairs can do when a client has no ID documents. So that's why it's critical that this life story, which is an alternative to formal ID documents, is done incredibly well, and why, very critically, there is no difference between what they say in their life story that they're writing up for citizenship. There's nothing different between that and what they've said in their visa application. I mean, their visa application could have been 10 years ago. You know, it could have been 6 years in the processing. And they finally got here. They've waited 4 years. People don't remember what they wrote. As I said earlier, they don't remember, or they didn't even do the application. So they don't know what's in there, but you can be certain that Home Affairs will be cross-checking what was put in that application with what is in this citizenship life story. You might remember I said before you do anything with the citizenship application, if you've got a client with possible identity issues, you must FOI their file. The reason why you should do it before they apply is because, again, we've seen clients who've had their applications refused because they have written their life story, or I'll just withdraw that. They've applied for they've applied for citizenship. Home Affairs have written to them and said, oh, you don't have any ID documents, or you don't have sufficient ID documents. Can you write us your life story? Tell us about yourself. Give us lots of detail. They then think, oh, well, I don't know. I didn't make my own application, my visa application. Somebody else did that for me. I didn't speak English. I'll get a copy of my file. So they FOI their file, and they get their file, and then they write their life story, cross-checking what they write in their life story with their application. Not because they're being not because they're lying about anything, just because they're like, oh, I don't remember that. That was a long time ago. Home Affairs have refused applications on the basis that the person must be lying because clearly they don't know their own life story, because they FOI'd their file after they've applied for citizenship. I've seen a refusal on that basis, that there's been nothing inconsistent because the client got their file, a visa application file, put their life story together based on their memory and what was written there. But they fell foul of that because Home Affairs said, well, if you really were telling the truth, you would really remember everything and you really would not have had to FOI your file. So FOI before you make the application, not in the middle of the application. I could go on and on about that. There's so many stories that are pretty alarming. I should say we'll talk about appeal very briefly, but they would be one of the times when you might think about appealing a decision on that basis. Anyway, that's the first.
People are just asking the clarification about FOI. I don't think everybody knows.
Oh, sorry.
FOI.
Yes, a lawyer thing. Okay, so FOI is freedom of information. So there is a form that you can use to get a copy of your client's file, which is their visa application file, indeed any file. It's called the 424A form, and that's a form that the client fills in, sends to immigration. It's free, saying, please send me a copy of my visa application file. And they will copy everything that is on that person, under that person's name. And that will always include their visa application, which is the form that they filled in, or somebody, probably more likely, the form somebody filled in for them, plus any documents that they gave at the time they made the application, plus, really critically, a transcript of any interviews that they had. So everybody gets interviewed before they get a refugee visa, and on their file will be a transcript of the interview. That's always really interesting because clients are often asked about things like, oh, where did you come from? What did you do then? Who's in your family? How did you get to Thailand, or wherever it was that they got to? So that's really useful for putting together a life story for citizenship applications, and critical if the client doesn't have their own documents or a copy of their visa application. And I don't think I've ever seen a client who has a copy of their visa application. Never. So that's what that is. It's free. It's supposed to take 30 days. It never does. It takes months sometimes for Home Affairs to give the client back their file. But it is, despite the delay, well worth waiting to get it before you endeavour to apply for citizenship. Sorry, Bridget, is there any other questions? That was just the FOI.
Look, there are a number of questions. I wasn't sure at what point to ask them, but I imagine you might want to go on to character issues.
I might just do
first.
character briefly. Yes. So the next issue that we come up against for our clients in citizenship are character issues. And kind of interestingly, this tends to apply to different communities. What we are unfortunately increasingly seeing with our clients is issues that arise in the context of domestic violence. So if your client has a criminal record, which means that they've been convicted of an offence, doesn't mean if they've had just an AVO, that's not a criminal matter. Only if they breach it, which means they do something that's wrong, that's against the AVO. So if they've got a criminal record, they're going to have character issues. It's immediately going to come up. Generally, having said that an AVO is not a criminal issue, generally an AVO will go hand in hand with an offence we call common assault, and that will mean that they have been to court about that. So the judge will say, well, we're going to give you an AVO, you have to stay away from your husband or your wife for 12 months, and also I'm convicting you of common assault. They generally go hand in hand. It's the common assault issue that will come up on their criminal records check, which is something that Home Affairs will do once they've put their application for citizenship in. So Home Affairs will do their own check, and it will come, if there's something on the client's record, it will pop up, and Home Affairs will then write to the client and say, tell us what happened. We see that you've got an AVO, or we see that you've been convicted of common assault. Can you explain to us what happened? And so they will basically be putting the client on notice that their application may be refused because they're not of good character. So being of good character is one of the basic tests that you have to pass. You have to prove it. You have to prove that you've been here for 4 years. You have to pass the citizenship test. You have to prove who you are. That's your identity issue. And you have to prove that you're of good character. So we're getting down to the line now. When they're starting assessing character, then we're getting close to the point of a decision. It's unfortunately coming up quite a lot. I guess all I'd say to you is be aware of it. There's really nothing that you can do about it. If a client's been convicted of a common assault, then they've been convicted of a common assault. The advice that you would be giving to clients about character when that arises is, firstly, they need to get legal advice before applying. And the second thing that I'd say is that if there is still an AVO in place at the time they plan to apply for citizenship, then you should discourage them from doing that, because the law actually says there's no discretion. If you are subject to an AVO at the time you make your application, you will be refused. We cannot give you citizenship whilst that's on foot. So they will get a very quick refusal, and their $490 will be lost. So that's really important. The other thing that when clients get that advice, then what they think is, well, you know, the week after the AVO is finished, you know, the wife and I have reconciled, we're back together. It's been a week since the AVO is finished. It was a year ago that I was convicted of the common assault. I'll apply now. Also a very bad idea. They should wait sometime after the criminal conviction and the expiration of any AVO, if they've got one, before applying. There's no set time. It's not like, well, wait 2 years or wait 1 year. It depends on, I guess, the severity of the offences, and I guess, and the frequency. It kind of depends on what's in their criminal record. For somebody with quite a serious criminal record, where, say, there's been a few incidents of domestic violence, I would counsel them to wait probably about 5 years. I'm talking about somebody with a serious, you know, quite serious, lengthy criminal history. For someone who, say, has an AVO against them, that's finished. They were convicted of common assault. It's been maybe a year since the AVO finished. That probably is, you're getting closer to the time when you think, yeah, I can prove now that I'm of good character. The issue with the time between when an AVO finishes or when you were convicted of an offence and when you apply is this. It's important because what you have to be able to say to Home Affairs is, yes, I did that. Yes, that happened. Yes, I've been convicted. But since then, things have been good. I haven't reoffended. I haven't done anything. There haven't been any AVOs. It's easy to say, well, it ended last week and I've been really amazing since then. That Home Affairs will look at that and say, yeah, but that's 7 days. What we want to see is a really entrenched pattern of good behaviour before you apply. And so that's why we say to clients, please wait some time before the offences, before the AVO, please wait some time after the AVO has finished before you make the application, because you risk having it refused almost immediately on character grounds. I think I'll say maybe one last thing and then I'm finished, and then of course I'm open to answering any questions. The last thing I'll talk about is citizenship refusals, and I'll really just touch on this very briefly. If the application for citizenship has been refused, then they need to get advice almost immediately. You've got 28 days to apply to a place called the AAT, which is the Administrative Appeals Tribunal, but that time can be extended. And often people don't apply within 28 days. It's not one of those very strict time limit ones. So if you have a client and you send them in to see us and it's day 40, we can probably swing that if we think that there are grounds for appealing. On appeals, though, I should say most of the decisions that I see are not amenable to appeal. That you just wouldn't appeal them. They might be things about, and they often are, things about exemptions, often on medical grounds, and for different reasons, which I could probably go into if I had more time. It just isn't worth appealing them. The better thing to do is just start again. On the question of having said that, some decisions absolutely should be appealed, and certainly we will assist people on appeal if we think there are grounds for doing that. You have to pay an application fee to the AAT. It's $952. That's right, almost $1,000. But if you're on Centrelink suffering financial hardship, then the fee is $100. So in those cases where you think there is a real prospect here, much better for the client to apply to the AAT, it's $100, than to reapply for $90, which is a new application. So I'll just leave that at there. There's probably a lot to say about appeals, but what I guess I'd say to you is this: if you get a client and you read the decision and you think, gee, that doesn't sound quite right, you can send it in to us. We will have a look at it, and then we will let you and the client know whether we think there are grounds for an appeal, or whether, more generally, we would say, no, you just need to apply again. Time to appeal, I've got that up there, 28 days, cost is $960 or $100, as I just covered. But again, we can help people with that process. If we get to the point where we think an appeal is something that a client should do, as I say, we can assist them with that, and we can walk them through the process. If a person has a grant of legal aid to assist them, which they would if we were helping them, then the fee of $100 automatically applies. So that's something good to know. Okay, that's it for me. That's all I'm going to cover today, which is a lot. Bridget, I think on the screen now is a way that people can contact us if I'm happy for them to send through questions, and I will answer them, or to book a client in. The best way probably of referring clients is through our email address rather than the phone, but either way is fine. Bridget, do you want me to answer any questions? Is there anything that you think I should answer now, or?
Well, there are a few, and it might benefit other audience members if you're happy to run through.
Sure, very happy
some
to.
questions.
Sure.
Okay, the first question is, my client wants to visit his country after getting citizenship. He's worried about his citizenship being revoked.
No, so he shouldn't worry about that. You can only actually have your you can only have your citizenship cancelled or revoked, cancelled, if you have committed a fraud in getting your citizenship. Now that's kind of complicated and complex. It basically means that you've lied on your citizenship application. Our view is that there's hardly any prospect of anybody being able to lie in their citizenship application, because everything is so highly scrutinised and cross-referenced. If they think that you're lying, you'll just get refused. So fraud hardly ever applies to our clients, but you can only be cancelled on that basis, that you have committed a fraud, which is a criminal offence, and you have been prosecuted criminally for fraud. Only then can the citizenship be cancelled. So once you've got citizenship and you've got your passport, you're pretty safe. So,
Thanks.
Yeah, frankly, it's almost impossible to cancel a person's citizenship.
Okay, the next question is, if the husband becomes a citizen, then does the wife need to wait 4 years, including the 1 year of permanent residency?
She does. Yeah, she does. She does. So sometimes we'll have, like, the husband will be here first, and so he's met the residence requirements, and then the wife might come later because she's applied for a partner visa. Each of the applicants, the adult applicants, have to meet the residence requirement, which is what we call the 4 years. So she has to have been here lawfully for 4 years, including 1 year as a permanent resident. She can't ride on the back of her husband's residence. She has to independently. And if she's brought kids with her, so the kids have come with mum, the kids also have to have been here for the 4 years.
Thank you. Question about processing time. Is the processing time from the date the application is submitted?
Yes, it is. So that 18 months that Home Affairs are giving, which they say 90% of applications are processed in 18 months, that's from the date that the application is submitted.
And a question about permanent residence. Is the definition of living in Australia for 4 years inclusive of time spent travelling overseas, or only when they are actually in Australia?
So it can include short periods of time overseas. It does. I mean, if there's a kind of a mathematical calculation that Home Affairs will do, I think, which I won't go into because it's complex, but I think if you've got a client who has spent really substantial amount of, so they've got permanent residence, they've entered as a permanent resident, and then over 4 years they've spent a substantial amount of time, and that for me would be anything more than 2 years collectively. overseas, then they need to be getting advice, because you're right, it's a really good point. They might not meet the residence requirement. It's not enough just to be a permanent resident and then go overseas for 4 years and say, hey, I've been a permanent resident for 4 years. That won't meet the residence requirement. So it's a bit of a sliding scale. There's no short answer. It depends on how long they've spent overseas and how long they've been here.
Okay. I think you may have answered this question during the slide that you were addressing it, but I'll just ask it anyway.
Okay.
Does a person need to pay a fee each time they take the test? I know you gave the example about someone that had taken it 22 times.
Yeah, he did.
Or generally it's 3 times, I think you said.
Yeah, so generally it's 3 times. So there's no fee applied to the test. It's just the fee is the application. So you pay $490 for the citizenship application. And, you know, you can go and do the test usually about 3 times. And then if you fail, then you'll be refused. And then you need to make a whole new application for citizenship. You start again. You don't just apply to have another test. You start entirely again. So yes, you would need to then pay a new fee because it's an entirely new application.
Does that mean the client that sat the test 22 times had paid the fee?
He set the test. So he applied once and then they let him do the test over and over and over and over again. No fee applied to that. So the fee applies to the application itself. The fee doesn't apply to the test. You're not paying for the test. You're just paying to put the application into Home Affairs. Yeah. So it doesn't matter how many times Home Affairs allow you to do the test. The fee is still $490. Although ultimately, as I said, if you keep failing, they'll just refuse you, and that means you've been refused your application. Start again, pay another $490.
You referred to people being able to transfer children from one parent to another, and someone has asked, what form do you use to apply to transfer a child?
Yeah, no, there's no form actually. It's stuck in the law somewhere, and I have to be honest, we only recently discovered this, like in the last 3 months. We didn't know that you could do that. There's no form. I think it would just be a letter to Home Affairs with, you know, the reference number for dad, the reference number for mum, and then please transfer these children to dad or mum. So there's no actual form. It's not something that I think Home Affairs want people to know about. I would say about that, that everybody still has to meet the residence requirements. So sometimes dad's here before, he's put the application in for citizenship, mum arrives with the kids, and then dad says, and then she applies later. He's still waiting and he says, oh, well, I want to transfer the kids over. Mum and dad have to apply at the same time. So they have to, the law says applications made by parents lodged at the same time. Now, does that mean the same day? Does that mean like the same minute? It's not clear. So what I'd say is if you have a client like that, let us know and we will write to Home Affairs pointing out their own piece of law that says that they can transfer. And so we would help clients to do that, because I don't think it's that straightforward. And I suspect we didn't know about it, and probably Home Affairs Citizenship section probably don't know about it either. So you might get a bit of pushback if you just try and do it yourself.
Okay. I think you have answered this, but if a client has sat the citizenship test 3 times and failed all of them, what happens next? So I'm assuming from what you said,
they'll get refused. Look, yeah, they probably will get refused. Although, as I said, you know, I had a client who was invited back again and again and again, which seemed very indulgent of Home Affairs. But then I've had other clients who've done it 3 times, and then the next thing they get is the refusal. So they'll get the letter from Home Affairs saying, you've sat the test 3 times. We're now refusing you. Please apply again when you can, basically, apply again when you speak better English. Really, that's what they're saying. Or they might get really lucky, and the next thing they hear is, we're giving you another turn at sitting a test. Please come to the Centrelink office in Wagga next week. Like, you just, there's no policy around that. There's no law around it. So it kind of depends on the discretion of the decision maker. But I think most likely clients will be refused after 3 times and they will have to start again.
Thank you. There's a question about a dependent child on a parent's application. What happens if they have turned 18 by the time the application has been approved for a citizenship test? Would the child have to take the test?
I don't think so. I don't know. That's an interesting question, and I don't know. But I would think that, and I can follow that up if you'd like me to, if you can give us your name and your details. Most of the criteria that applies is what we call time of application criteria. So, and that's because if Home Affairs drag their feet and take years to process and things have changed for a family, then that family shouldn't be disadvantaged because Home Affairs are slow. So what they say is if you meet the criteria for this visa or for this citizenship at the time of application, then that is the criteria that applies all the way through. So I suspect the answer is if they didn't have to do the test because they were 17 when they applied and now they're 20 because Home Affairs have taken 4 years, they probably don't need to do the test. But again, if you give us your details, I'm happy to look that up and confirm that and send you that confirmation if you like.
When people register, they provide an email address, so we can provide that.
Extract
so
that.
you'll be able
Okay.
to follow up on that. Yeah.
Okay.
Another question. One client has an intensive correction order. Would he be eligible for citizenship?
No. If he has a current ICO, again, the law says, which is an intensive correction order, the law actually, the Citizenship Act, which is the law, when I refer to the law, that's what I'm referring to. There's actually a part of the law that says you cannot, it's not even discretionary, you cannot get citizenship until after that has finished. And what I'd say is, I just confirm what I said earlier, that even when it's finished, he or she would need to wait some time until after it's finished to prove that he or she is of good character. So in short, no, do not apply while that is on foot because they will immediately get refused. They don't get their $490 back. The $490 goes and they've paid the fee with no hope at all of getting citizenship because the law says they can't.
Okay. Another question is, my client is living in Australia for 20 years. She is a permanent resident. She is assuming she doesn't need to do a test. She is 40 years old. I'm telling her that she's incorrect. Am I right?
You are right. Yeah. There's no exception to the test if you've been here for a really long time. The law that applies is the law that applies at the time you make the citizenship application. It doesn't matter if you came here 50 years ago or 4 years ago. The law now says this is the law that applies to you. And that law is, if you've been here for 4 years, that's a very big tick, been here for 20. If you're between 18 and 59, you have to do the test, tick, to do the test, she's 40. If you don't have a disability, no, then you have to do the test. She has to do the test if she applies. No exemption because she's been here for a long time. That's not one of the exceptions to the test.
Okay, thank you. Another question, does Home Affairs view offshore criminal conviction, which was an assault on police, in the context of politically related protest? How does Home Affairs view an offshore criminal conviction in the context of politically related protest a few years ago?
Yeah. So, often, so if it's something that occurred offshore, so it's probably likely before the person was granted a visa. And so their character would have been assessed at that time anyway. And as you say, it's all about context. I would think that will be an issue that is already known to Home Affairs because, again, it would have come up when the person applied for their visa. With the citizenship applications, they don't ask people to get police checks from their home country, and that's because our clients are refugees and they've been granted protection against their home country. So why would we then compel them to go back to the authorities of their home country to ask them if they've been good people? So that won't come up for citizenship necessarily. You'll know on the citizenship form, though, there's a series of questions about character, and it says, have you been convicted of this, that, or the other? And so the client would say yes. And then, of course, I think that they would then, and then it says, if you've ticked yes to any of these questions, then provide some details. So I think that person would very likely be completely fine, but they would need to explain what had happened and why they have this conviction.
Okay. Another question. My client came to Australia 1 year earlier than her children, and the children are all under 16. Can they apply under the same application?
Yes, I think they can. They don't have to meet the residence requirements if they're on their mum's application, in short.
Okay. Just another question about intensive correction order. Is it considered as criminal on records? Is it?
Yes.
It would go on a criminal record.
Yes. Yes. So an ICO is the ICO is if you like, the punishment. That's not the offence. The ICO is not the offence. So I don't know what the offence is. So it's probably assault. It sounds like it's reasonably serious. An ICO is pretty serious. It basically means, though, instead of sending you to jail, we're going to release you on. Basically, it's basically a good behaviour bond. So we're going to let you out, but if you do anything, you're going into jail. So that's what an ICO is. So the offence might be, say, assault, and that is the thing that will come up on the criminal record check. They'll also say, oh, and he got an ICO, or he went to jail for 6 months, or it was no conviction recorded. We call it a section 10. So there are a whole bunch of things. So the judge says, yep, you're convicted, you did this thing. Now let's talk about what punishment we're going to give you. So the ICO is the punishment, it's not the offence. So that will definitely come up on that person's record, undoubtedly. And they should not apply whilst that's on foot, because the law says they will be refused.
Okay, so that looks like all the questions that people have submitted so far.
Okay. All right then. I think we were scheduled to finish at 3:30, so I apologise for going longer. It's a lot to cover. I think, as we said in the invite, or the thing that notified you of this, is I'm going to prepare, based on this presentation, a guide to applying for citizenship, and it will cover, but in more detail and with less me talking, all of the stuff that I've covered today, so that you'll be able to look back at what I've talked about, and reference some of the things that I've covered, and hopefully be able to, at least, if not help your clients fill out applications for citizenship. I think one of the things that we hope is that you'll be able to identify when a client definitely needs to get some legal advice. The stock standard ones are easy. We all do those all the time, and it's the problematic ones where people need to be given some advice, which of course we're happy to do. So that will be prepared hopefully this week, fingers crossed this week, and I think that you'll get an email containing that at some point. Is that right, Bridget?
Yes, we can
happen?
send an email to everybody once that's available.
Okay.
And of course, everybody would have, once they registered, the CLE email address, and they'd have your email address from the slide on screen if there's any further questions. Okay,
perfect. Okay, well, if that's it then, thank you everybody for coming along. Look forward to those referrals, and I'm sure I'll see some or all of you at some point in the future.
Thanks everybody for attending, and
Thanks,
thank you,
Bridget.
Lynn. That was a really informative.
No worries. Thanks everyone.